particular investigation was conducted by Robert Caswell Investigations, RCI, specifically by investigator Brett Dennison. The investigation was assigned to RCI by the City Attorney's Office on April 22nd of 2018 and completed May 21st of 2018. I received a copy of the investigative file on September 7th of 2018, and I actually examined the original file at the City Attorney's Office August 24th of 2018. The investigation examined the conduct of Lieutenant G under two specific SOPs. 1-1-4D19, personnel will not alter, misrepresent, or make any false statement in any verbal or written report or in any other written document that has been completed in the course of their employment. And 1-1-4B5, personnel will not commit any act that constitutes a violation of the rules, regulations, directives, or orders of the department, to include but not limited to those outlined in this policy. Personnel will at all times be held accountable for their personal policy and procedure violations and must report any such violations to their command. The first SOP carries a sanction level of 1 through 7. The second carries a sanction level 4. The investigative file does not contain a chief's recommendations page, nor does it contain any aspects relating to discipline. The board and the public expressed concerns that Lieutenant G may have received favorable treatment because of her relationship with another member of the Albuquerque Police Department. I can assure you that did not occur, nor did Lieutenant G commit any crimes, nor let alone felonies. As I review this investigation, my opinion is a preponderance of the evidence shows no SOP violations occurred. The gist of the case is an investigation was completed on the 22nd of February of 2018. On the documentation within the file, there was a notation that the internal affairs review had taken place on the 23rd, one day later. The allegations are that that review did not actually occur until the 26th. What's pivotal is that the 120-day investigative period ended on the 23rd. This entire case is based upon a false narrative. All parties agree the investigation that contained the alleged backdating was completed on February 22nd of 2018, a day prior to the 120-day deadline. Therefore, in compliance with the collective bargaining agreement, the fact that Internal Affairs may or may not have concluded its review until the 26th of February is irrelevant to the chief's ability to impose discipline. It simply means the command staff would have had less days to conduct its review. In my opinion, the investigation was flawed in many ways. First, it fails to examine the bias of two disgruntled internal affairs detectives. Those two detectives brought forth the allegations against Lieutenant G as they were facing the prospect of discipline. Two, the investigator establishes a fact pattern at the initial interview and then seeks facts to support his already reached conclusion. He begins most of his interviews by saying, "Here's what I know." Third, he relies on the IA Pro audit trail to show that the only complete printing of the investigative file was on 2/26 of 18, when all parties acknowledged that paper copies of the file existed from other printing sources. The investigator draws the conclusion that a review could not have taken place until February 26th of 18, when in fact all parties acknowledged paper copies of the file existed previously because Lieutenant G had rejected the work and sent it back for rewriting. None of those printings, in fact, are reflected on the IA Pro audit log. Fourth, 3 witnesses gave statements that a paper copy of the file was printed on 2/23/18, the date that Lieutenant G initialed she had reviewed the file. And lastly, the investigator lies to Lieutenant G, telling her he has the audit trail from all the other printers in the office to show that the printing did not occur, when in fact he did not contain or have those audit files. So I stand for questions.
Okay. Do we have any questions? Chelsea?
Yes, I have a question. Thank you for executing the review as the board requested. I unfortunately am not great at auditory processing, so it's really helpful for me to be able to read things. I don't know if you could give me what you've typed up at a later date. But the one question that I do have based on what I was able to process is what then is the explanation of the demotion? Because the demotion was purported to be connected to sustained allegations. And if the allegations really fell flat through this investigation, then what would the explanation for the demotion be?
Chair Waits, Member Vandeventer, the investigator in this case did sustain the findings. He relied solely on the printing of the case on the 26th based upon the audit trail from IA Pro. So it was his recommendation that went forward. Also, within the interviews, there's been reports that there was a confession, and that was not in fact true. There was an acquiescence to, well, if you in fact have this evidence, then I cannot refute that. When in fact the evidence that the investigator claimed to have, he did not have. And if he had it, it is not in the investigative file.
Okay, thank you.
So it's your conclusion that the investigation was so flawed as to not be credible, and that there were consequences inflicted on Lieutenant G based on a flawed investigation.
Chair Waits, Member Fine, that is my opinion based upon my review of the investigation.
Okay, so the things that were in the paper had to do with backdating things. You're saying those things didn't happen.
Chair Waits, Member Fine, my belief is that a preponderance of the evidence shows that a review of the file did occur on the 23rd of February, and that is exactly when it was initialed off as having occurred.
And it wasn't backdated, it was dated the date it was supposed to be.
Chair Waits, Member Fine, that's correct.
Okay. So my question to the board then is, should we not share this information? What do we do with it? I mean, it's satisfying to me to know that that there was no conflict of interest, no favoritism shown. But we have information that may not be available to everyone. Should we do anything with it?
Do we share it like we would any of your other findings with Chief Barrett?
Chair Waits, Member Galloway, the city already has all of this information. This is based upon my review of the file. They have the file. I went and looked at the original at the city attorney's office. So they have all the information, and the disciplinary procedures that would be in place for Lieutenant G if she were a lieutenant do not apply, because at that point she was of a higher rank. So I don't believe that there are any steps. I think that what the board was seeking was confidence that there was not favoritism in this case, and I think that the board has done its public service in showing that in fact did not happen.
Thank you, Mr. Harness.
Any other comment before?
So the new information is that you have concluded that she was within her Wright or Lieutenant G, was, acted appropriately. That's the new information we have, right?
Chair Waits, Board Member Dr. Cass, I don't know that it's new information. This is simply my review of the information, and it's my opinion that a preponderance of the evidence shows that there was no violation.
So that would, it seems to me if we're going to call attention to anything, that would be what we have to call attention to.
And I think it is public record now, and so there's nothing that we can do about it.